Before we start today's lecture, let me ask you one question. If tomorrow, in your CS executive exam, the examiner gives you a practical case and asks, is this receipt a deposit or not? Will you be able to answer it confidently in less than 1 minute? If your answer is not a confident yes, then don't skip even a single minute of today's lecture. Because today we are going to complete the remaining most important questions that can directly appear in your examination. Welcome back, everyone. In our previous lecture, we covered the first 17 practical questions on the definition of deposit under Section 231, read with Rule 21C of the Company's Acceptance of Deposits Rules 2014. Let's do a super fast revision before moving ahead. Question 1. What is the definition of deposit under Section 231? Question 2. Why did Parliament use the word includes instead of means? Question 3. Why should Section 231 always be read together with Rule 21C? Question 4. Why is RBI consultation mandatory before prescribing exclusions? Question 5. What is the legal consequence if money is classified as a deposit? Question 6. How does Rule 21C expand the definition given in Section 231? Question 2. What are the 4 practical steps to determine whether a receipt is a deposit? Question 8. Are all 18 exclusions unconditional? Then we covered the first 9 exclusion clauses. Question 9. Government money. Question 10. Foreign money under FEMA. Question 11. Bank loans. Question 12. Public financial institution and LIC loans. Question 13. Commercial paper. Question 14. Intercorporate loans. Question 15. Share application money and the famous 60 plus 15-day rule. Question 16. Director's loan along with the written declaration and board's report disclosure. Question 17. Secured debentures and listed non-convertible debentures. If all these 17 questions are crystal clear, you've already mastered almost half of the practical framework under the deposit rules. But don't relax yet. The remaining questions are equally important because this is where the examiner usually tests time limits, conditions, exceptions, practical illustrations, and tricky case studies. So in today's lecture, we'll complete all the remaining questions and answers, understand every provision through practical examples, and by the end of this lecture, you'll have a complete conceptual understanding of Section 231 read with Rule 21C. So keep your Bear Act, notebook, and highlighter ready. Let's begin with question number 18. Let me ask you one practical question. If an employee gives a company a security deposit, is it automatically a deposit under the Companies Act? What if a customer pays in advance? Or what if a company is simply holding money in trust? Most students answer these incorrectly in the exam because they remember only the provision, not the conditions. Today, we'll solve that problem forever. Welcome back. In the previous lecture, we covered questions 1 to 17 and understood how Section 231 and Rule 21C work together. Today, we'll continue with questions 18, 19, and 20, where the examiner usually asks practical case study based questions. Question number 18. Employee security deposit. Can a company collect a security deposit from its employee without treating it as a deposit? The answer is yes, but only if 2 important conditions are satisfied. Condition number 1. The security deposit must be non-interest bearing. Condition number 2. The amount should not exceed the employee's annual salary. If both these conditions are fulfilled, the amount is not treated as a deposit under Clause X. Remember this illustration. Suppose a cashier earns 6 lakh rupees annually and the company collects a 1 lakh rupee non-interest bearing security deposit. Since it is below the annual salary limit, it is not a deposit. But if the same company collects 8 lakh rupees, the annual salary limit is crossed, and the excess amount may lose this exemption. Exam tip. Always remember the formula non-interest plus annual salary limit equals not a deposit. Question number 19. Money held in trust, clause 11. Now imagine another situation. A company receives money but is not allowed to use it for its own business. Is that money a deposit? No. Clause 11 excludes any non-interest bearing amount received and held in trust. Here, the company is only acting as a trustee or custodian, not as a borrower. For example, a company collects contributions for an employee welfare fund and keeps the money separately without using it in its business. Since the company is merely safeguarding the money, it is not a deposit. Golden rule. Trustee holds money, borrower uses money. If the company is only holding the money in trust, deposit rules do not apply. Question number 20. Business or trade advances. Clause 12 A to G. Now comes one of the most frequently tested topics in CS executive examinations. Students often assume that every advance received from a customer is a deposit. That is completely wrong. Clause 12 excludes several genuine business advances, but every category has its own conditions. Let's understand them quickly. Advance received for goods or services is excluded if adjusted within 365 days unless there is a pending court case. Advance relating to immovable property is adjusted according to the agreement. A performance security deposit received under a supply or service contract is also excluded. Advance for long-term capital goods is excluded. Advance for warranty or maintenance services is excluded if the service period is within normal business practice or 5 years, whichever is less. Advance received under directions of a government or regulatory authority is excluded. Advance received towards a publication subscription is also excluded until adjusted against future delivery. But don't forget the most important proviso. If an advance under clauses A, B, or D becomes refundable because the company never had the required approval or permission and the refund is not made after 15 days from the due date, that amount is treated as a deposit. This is where students lose marks. Now look at the practical example. A furniture manufacturer receives 2 lakh rupees as an advance for a custom order and delivers the furniture within 6 months. This is not a deposit. But if the company neither delivers the goods nor refunds the money even after 365 days and there is no pending litigation, the amount can become a deposit under the rules. Quick memory formula. Remember these 3 clauses using one simple sequence. Employee security deposit, non-interest plus annual salary limit, Rust Money Company is only a custodian business, advances genuine business purpose plus time limits plus conditions. If you remember this framework, you can solve almost every practical question based on these clauses. Now let's move to the next set of practical questions, where we'll cover promoters' loans, Nidhi companies, chit funds, collective investment schemes, startup convertible notes, and SEBI registered investment funds. Those are also highly important from both the examination and practical compliance perspective. Let's continue. Questions 21 to 24, Clause 13 to Clause 16. Here's a tricky exam question. A promoter gives 20 lakh rupees to the company. Is it a deposit? Most students immediately answer no. But that answer is only half correct. In company law, one small condition can completely change the legal position. That's exactly what we'll understand in today's lecture. In the last segment, we covered employee deposits, trust money, and business advances. Now we'll study questions 21 to 24, where you'll notice one common principle. Whenever another law is already regulating a transaction, the deposit rules generally do not apply. Let's understand this through practical questions. Question number 21. Promoters' unsecured loan. Can promoters bring an unsecured loan into the company without it becoming a deposit? The answer is yes, but only temporarily and only under specific conditions. If a bank or financial institution sanctions a loan to the company and makes it compulsory that promoters first bring their own funds as an unsecured loan, then that promoter's loan is not treated as a deposit. But remember the most important condition. This exemption survives only till the bank loan remains outstanding. The moment the bank loan is fully repaid, this special exemption also comes to an end. For example, a bank sanctions a term loan only after promoters contribute 20 lakh rupees as an unsecured loan. That 20 lakh rupees is not a deposit while the bank loan continues. Once the bank loan is repaid, if the promoter's money still remains in the company must re-examine whether it now falls within the definition of a deposit. Exam memory trick. No bank loan, no exemption. Always link the promoter's loan with the outstanding bank loan. Question number 22. Nidhi Company Receipts. Clause 14. Can money accepted by a Nidhi company be treated as a deposit under these rules? The answer is no. A Nidhi company functions under Section 406 of the Companies Act and is governed by the Nidhi rules. Since Nidhi companies accept deposits only from their own members and are already separately regulated, the general deposit rules do not apply. For example, a Nidhi company accepts recurring deposits from its members according to the Nidhi rules. This amount is not treated as a deposit under these rules. Remember, separate law equals separate regulation equals no double regulation. Question number 23. Chit fund subscription. Clause 15. Now, another practical question. A registered chit fund company collects monthly subscriptions from its members. Is this a deposit? No. Clause 15 excludes subscriptions received under the Chit Funds Act 1982. A chit fund is already a separately regulated financial arrangement. Therefore, deposit rules do not apply again. For example, 20 members contribute monthly subscriptions under a registered chit agreement. These subscriptions are not deposits. Golden principle. If the Chit Funds Act regulates it, deposit rules stay away. Question number 24. Collective Investment Scheme, Clause 16. Now let's move to another favorite practical question. A company pools money from investors under a SEBI-approved collective investment scheme. Will this become a deposit? Again, no. Collective investment schemes are comprehensively regulated by SEBI. Since investor protection, disclosures, and compliance are already governed by SEBI regulations, there is no need for another layer of regulation under the deposit rules. For example, a SEBI-registered company pools investor money for an approved agricultural land development scheme. That money is not treated as a deposit. Exam shortcut. If SEBI is regulating the investment, deposit rules normally do not regulate it again. Let's quickly revise today's 4 questions. Question 21. Promoter's unsecured loan is exempt only while the bank loan is outstanding. Question 22. Nidhi company receipts are governed by the Nidhi rules, so they are not deposits. Question 23. Chit fund subscriptions are regulated under the Chit Funds Act, therefore excluded. Question 24. Collective investment scheme money is regulated by SEBI, therefore excluded. Memory formula for the exam. Remember today's lecture with one simple line. Bank regulates to promoter loan exemption. Nidhi rules regulate to Nidhi receipts exempt. Chit Funds Act regulates to chit subscriptions exempt. SEBI regulates to collective investment money exempt. Whenever another specialized law already protects investors, the company's acceptance of deposits rules generally step aside. Now let's move to the final exclusions under Rule 21C. Complete all 18 exclusions and finish this chapter with complete exam confidence. Questions 25 to 27. One final exam concept. Can a startup or a SEBI registered fund give money without it becoming a deposit? Let's find out. Question 25. Startup convertible note. A DPIIT recognized startup can raise money through a convertible note without it being a deposit. Conditions. The amount must be 25 lakh rupees or more in a single tranche and all prescribed conditions must be satisfied. Exam formula. DPIIT startup plus 25 lakh rupees plus convertible note equals no deposit. Question 26. SEBI registered funds. Money received from SEBI registered AIFs, venture capital funds, InvITs, REITs, and mutual funds is not a deposit because these funds are already regulated by SEBI. Exam formula. SEBI regulated fund equals no deposit. Question 27. Depositor. Who is a depositor? A member depositing under Section 73 or any person depositing with an eligible public company under Section 76. Remember, ordinary company equals members only. Eligible public company equals members plus public. Quick revision question 25. Startup convertible note is exempt if 25 lakh rupees or more is received through a convertible note. Question 26. Money from SEBI registered funds is not a deposit. Question 27. Depositor means a member under Section 73 or a public depositor under Section 76. Memory formula. Startup equals convertible note exemption. SEBI funds equals no deposit. Depositor equals member or public under Section 76. With this, we have completed all the exclusions under Rule 21C. Next, we will study the remaining important definitions under the Company's Acceptance of Deposits Rules 2014. Questions 28 and 29. Eligible company. Section 231 versus Rule 21C. Here's a question that confuses many CA students. Can every public company invite deposits from the public? And if Rule 21C already explains deposit, why do we still need Section 231? Let's clear both concepts in just a few minutes. We've already completed all 18 exclusions. Now let's understand two important conceptual questions. Question 28. What is an eligible company? Can every public company accept deposits from the public? No. Only an eligible company can do so under Section 76. To become an eligible company, two conditions must be satisfied: net worth of 100 crore rupees or turnover of 500 crore rupees, shareholders' approval, and filing of the resolution with the ROC before inviting public deposits. Remember, a normal company accepts deposits only from members under Section 73, whereas an eligible public company can also accept deposits from the general public under Section 76. Memory formula: 100 crore rupees net worth or 500 crore rupees turnover plus shareholders' approval equals eligible company. Question 29. Section 231 versus Rule 2(1)(c). Are they the same? No, they work together. Section 231 gives the legal definition of deposit and authorizes exclusions. Rule 2(1)(c) gives the 18 detailed exclusions and their conditions. Golden formula: Section 231 equals defines the law. Rule 2(1)(c) equals explains the exclusions. 32nd revision. Q28. Eligible company equals 100 crore rupees net worth or 500 crore rupees turnover plus shareholders' approval. Q29. Section 231 gives the definition. Rule 2(1)(c) gives the detailed exclusions. With these two concepts, you've completed the legal foundation of deposit. In the next lecture, we'll move to the practical provisions relating to the acceptance of deposits under the Companies Act 2013. Questions 30 to 32. Final concepts. One final exam concept: what if a receipt does not fall under any of the 18 exclusions? Question 30. If no exclusion applies, the amount becomes a deposit under Section 231. The company must comply with Sections 73 to 76. Non-compliance may attract Section 76A. Exam formula: no exclusion equals deposit. Question 31. Some exclusions are conditional. Example: share application. Money becomes a deemed deposit if shares are not allotted within 60 days and the money is not refunded within the next 15 days. Golden rule: always monitor conditional exclusions. Question 32. Why is classification important? Because wrong classification can lead to penalties, while correct classification ensures compliance. Remember, classification is legal compliance. Quick revision. Q30. No exclusion equals deposit. Q31. Remember the 60 plus 15-day rule. Q32. Correct classification avoids penalties. Memory formula: no exclusion equals deposit. Conditions breached equals deemed deposit. Correct classification equals compliance. With this, we have completed Section 231 read with Rule 2(1)(c). In the next lecture, we will begin the practical provisions on acceptance of deposits under the Companies Act 2013. Before you leave, one quick question. If tomorrow's exam asks whether a receipt is a deposit or not, can you answer confidently? Let's revise in 50 seconds. Q1826. Employee security deposits, trust money, business advances, promoters' loans, Nidhi deposits, chit funds, CIS, convertible notes, AIFs, REITs, InvITs, and mutual funds all have specific exclusions. Question 2732. Remember the key concept. Section 231 defines deposit, while Rule 2(1)(c) provides all 18 exclusions. If no exclusion applies, it is a deposit and sections 73 to 76 become applicable. Golden exam formula. Money received arrow section 231 rule 2(1)(c). Check 18 exclusions. Verify conditions. Final conclusion. With this, we've completed 32 practical questions on section 231 and rule 2(1)(c). In the next lecture, we'll continue our Companies Act 2013 masterclass with the next important provisions of Chapter 5. If this lecture helped you, like, share, subscribe, and press the bell icon. Thank you for watching, and I'll see you in the next lecture. Jai Hind. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. They do not represent the views of my employer, any organization with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. The content is based on publicly available laws, rules, regulations, judicial pronouncements, and regulatory materials, or on hypothetical examples prepared for educational purposes. No confidential, proprietary, or unpublished information is used or disclosed. This channel does not provide legal, tax, financial, accounting, investment, or other professional advice. Viewers should consult qualified professionals before making any legal, business, or investment decisions. While every reasonable effort has been made to ensure accuracy, laws and regulations are subject to change. Accordingly, neither I nor this channel accepts any liability for any loss or consequences arising from reliance on the information presented. All trademarks, company names, and logos belong to their respective owners and are used only for educational, commentary, and informational purposes. Copyright Corporate and Securities Law. Compass, navigating law with clarity. All rights reserved.